I'm going to turn it over to Judge, who is going to talk about his perspective from the bench. I think he is our greatest cheerleader on the bench. He has bought in wholeheartedly, and we are so honored to have him here.
Well, good morning, everybody. Is this working now? All right. Okay, please be seated. If you'd like. It's very disconcerting being a judge when all of a sudden everybody stands up and then you remember that they're standing up because you walked in and you have to tell them to sit down. So we're going to slow it down just a little bit. I'm a pretty fast talker, but whoa, there's no way I can keep up with Jonathan Martinez. And I've heard Jonathan speak a few times now, and every time I listen to him, and I love listening to him, and I've been very inspired by his words and his work. I completely changed my presentation that I prepared because I always feel like, well, I'm gonna say some of what he said, which is going to be true, but I think the difference is that I'm a judge, so I am restrained in my advocacy. And Jonathan is an advocate, obviously. I also am an advocate in a different way. I'm not a practicing lawyer anymore. I loved being a lawyer. I loved advocating. But as a judge, I still think I have the responsibility to advocate for compliance with the law. And I have the obligation to advocate for justice in the law. And that's really my purpose for contributing to this presentation. Because what I think I've learned from supported decision making and what I've heard from Jonathan and other good lawyers like Amy Cunningham, Bob Aldridge, there are other people on the Lupe Ayala, where is she? Anyway, other people on the Dawn, people on the guardianship and conservatorship committee, which I've served on. Judy, sorry. If I missed anybody, I'm sorry, because this has been the most productive committee I have ever served on, and I've served on several. But what I've learned about supported decision making is that this is really the pathway to really complying with our law. The law as it is. I'm not up here talking about, as Jonathan said, a revolutionary shift in the law. What we're talking about is really a shift in the practice, the paradigm shift in how we approach these things, how judges approach them, how lawyers approach them, but more importantly, as Jonathan mentioned, this is kind of a bottom-up process. This paradigm shift, not a process, a paradigm shift, as he said, because really the information is coming from the people who are so affected by what we do in the court system. That's really where it starts. And then the people who work directly with the people who are affected are the ones who have the information, who bring the information to the visitors, who bring the information to the lawyers, who bring the information to the guardian ad litems, all of whom then bring the information to the court for a decision. And this can't be top down. If it were top down, it would have happened, because the laws in Idaho were passed in late 80s, really. That was really called the second reform of guardianship and conservatorship in this state. What we're calling, not we, I guess people who have some understanding of this and people who study this and talk about it and advocate for it, is that this recognition, or giving it a name, is really the third wave of guardianship reform. And as Jonathan pointed out, this is spreading throughout the country. It's just spreading fast because people are recognizing the injustice of not following the law. People are recognizing the injustice of taking civil rights away from individuals without justification, without the finding of necessity. And that's what's required in Idaho law. So that's why we really opened this CLE up to not just lawyers, because we want the teachers, we want the physicians, we want the social workers. And I see many of you are here from those disciplines. And that is so critical, because you are the front line on what is happening and really why it's happened. And so now, armed with this kind of information, I think you do have the knowledge to change our practice and really to change the world for the people who are so affected by what we do. Now, I don't know if you know this, but we did a presentation like this. It's constantly changing and evolving, I suppose, but we did it in Coeur d'Alene on Monday. Boise, and it's a beautiful day in Boise. Thanks for being in here. Boise today, and we're doing this in Pocatello on Thursday. And this came out of the Guardianship and Conservatorship Committee, which I got on in 2009. And I think those of you who work with guardianships and conservatorships in this state understand that during this period of time, I mean, really, so much of our practice has already been transformed. Not any big changes, just the practice. We haven't done any big changes of the law. And we've done that with really incredible support from the Idaho Supreme Court and the Idaho legislature. The fact that we have monitoring coordinators now in every district in the state, that's an incredible achievement for the legislature and for this state. When I first started on this committee, I didn't really know very much about guardianships and conservatorships. It just was not my thing as a lawyer. I really was more invested in coming into court and being an advocate and high conflict. I don't know why that appealed to me. And now I spend every day trying to tamp down the conflict. Maybe that's an irony of my life. But I learned pretty quickly what some of the problems were in the system. And it's funny, I mean, I didn't seek this out. I got a letter one day from Chief Justice Burdick who said, "You're going to be on the Conservatorship and Guardianship Committee." And I thought, well, the Guardianship and Conservatorship Committee, I don't know anything about guardianships and conservatorships. What, can I be on the Evidence Committee or maybe Civil Rules? And I really very quickly embraced it, and I'm so grateful because it's taught me so much about guardianships and conservatorships and the people affected, and that's really why I'm here, because I think what we're talking about is so critically important in applying the law. That's why under peer pressure, I had to prepare a couple of PowerPoint slides, which is not really my thing either. Better lives is a verb. It could also be an adjective, but so I'm gonna go to my first slide, because why are we doing this? Well, there are lots of reasons, and it's just really a repeat of what Jonathan told us. I mean, really, it's to protect self-determination, to protect autonomy, to protect rights. And it's that fundamental. This is the core of who we are as people. And we have a responsibility to do this work. And we are the people who are touching people's lives in ways that we haven't always appreciated fully. This idea of, because we are well-meaning in doing this, but this idea that really protecting self-determination is fundamentally the best way to protect a person is really profound. It really is kind of a change in how we think things. It takes away that kind of paternalism that is baked into our culture in this area. And I mean, if you have kids, you kind of know this from raising your own kids, and you know it from your own life. Yeah, I mean, I've learned a lot more from my mistakes ever than my successes. They dim pretty quickly, the successes. But the mistakes, the bad decisions, man, I've learned a lot. And it really is a huge part of who I am today. And I still make lots of mistakes, and I still make bad decisions, because what is that? Being human. You know, we're not perfect, none of us, and we never will be. So I could get really philosophical here. So I'm going to focus on the law. So I'm not going to read that. You just heard all these, but I just wanted to emphasize that. So here's one of the great advantages of living in a state like Idaho. And this, I've learned this from being in the judiciary and from being a lawyer and serving on committees, is you can really have a big effect because it's a small state, and this state is willing to be innovative, I think, especially in the judicial branch. I know we're willing to try things. We're willing to experiment with things. I don't think we're mired down in maybe some, but not too much, and this is the way we've always done it. Let's be willing to look at it, analyze it. We're doing that in sentencings. We're doing that in specialty courts. We're doing that in guardianships and conservatorships. So I know this is a very conservative state, whatever that means, but it's also very, very innovative in terms of how it's approaching the issues that our communities have to deal with. So I think I've already touched on this, but why did we want so many people of different disciplines to come to this? Well, I've already told you, because this has to come up from the bottom. This has to come up from the teachers and the social workers, the physicians, the counselors, the parents, the proposed guardians, and most importantly, the people who are affected by a potential guardianship. It's so important. So we can't do it without you. That's the bottom line. I mean, we really can't. Judges, I mean, if I just sat up there and said, every time somebody presented a total guardianship petition to me that wasn't justified, and all I did was say no, which I've done, and I will do, that doesn't really help change the practice so much. Ultimately, I suppose it would be. I think there is a question, well, when does this start? When is this going to happen? Right now. It's happening right now. That's what we're doing. That's what we're trying to do. The committee thought it was so important to take this message out into the state. And so not only are we trying to help sort of invest you with the knowledge and the will to get this word out, but to talk to other people that you work with, that you know, and help them really understand what we're trying to do. And I think that's how it's going to happen, and that's how it is happening. I mean, I know since we have changed the visitor reports and the executive committee reports that I've seen coming from health and welfare, the executive committee reports, they are vastly improved from what I'd seen historically under new rules 54.4, 54.5. Remember, those are in the administrative rules. And I've had recommendations from those reports to not grant the guardianship. I've had recommendations in those reports to delay, to consider particular issues. We need more information. That's the kind of process that we want to see because of historically just defaulting to total guardianships. Now, as you know, there are 3 types of guardianships, but first, because I'm supposed to talk to you about the law, I'm going to tell you, in a nutshell, the law, okay? This is the law in a nutshell, through my perspective, that we have to really consider when we consider guardianships and conservatorships. And of course, the thing always lurking around in the background, maybe lurking is the wrong word, is the Due Process Clause of the United States Constitution and the Idaho Constitution. I mean, when we take away somebody's rights, when somebody's rights are affected, affected without due process, that's a violation of the Due Process Clause of the United States Constitution. That's a violation of Article 1, Section 13, which is the Due Process Clause of the Idaho Constitution. So that's in the background, and I'm not going to get too far into the weeds on that, but I think at some point we'll likely see from somewhere in this country case law that says that people have a right to have counsel appointed to represent them at public expense. Is the civil Gideon principle. I don't think we're there. I think maybe Massachusetts has a case. So it's, I mean, that kind of discussion is out there in the legal world. Of course, the ADA, we have the Olmstead case, which Jonathan mentioned, really important United States Supreme Court case. We have the Idaho statutes, which now I'm going to focus on, and then these administrative rules dealing with guardianship reporting and reports, also relaxation of ex parte contact in the court system sort of modifies the rules of judicial conduct. The reason that's important is that I think lawyers and judges need to really appreciate this. Guardianships and conservatorships are a different kind of legal proceeding, legal result than most cases. I mean, we learn as lawyers, we just want to get it done, close the file, get it out of the queue for, well, I guess you're all using Odyssey down here now too. Get it out of the queue, you know, be done with it. I don't want to think about it anymore. But guardianships and conservatorships are different. And I think lawyers need to appreciate, especially guardian ad litems. This is one of Bob's huge issues. Guardian ad litems are on the case forever, okay, until that guardianship is terminated or the person dies. But the lawyers need to be aware of that too. It continues. It's not fixed. I said this earlier. Judge Peterson described this. I'm stealing it, really. That you know, judges have been just flipping a switch. The guardianship is on, the guardianship is off. It's more complex than that. It's more nuanced than that, as you've heard from Jonathan. And it's a continuing spectrum of life with changed circumstances. Wow, that's really hard. I mean, some of you maybe have dealt with child custody cases, I assume. That's pretty hard. Deciding what's in the best interests of children. Well, I mean, why do we shy away from understanding just how complex determining the appropriateness of a guardianship can be? Because I think we do. I mean, we need to sort of embrace that it is hard, but incredibly satisfying to do the right thing and not just default to total guardianship. So there's the law. That really kind of completes my presentation right there. All I need to do is tell you the law. Well, I'll keep going now because I made these slides. All right. Here's the incapacitated adult statute. And I put this up here. I'm not going to take you through the whole traipsing through the statutes, but I think this is really important. I just highlighted the language of the statute. And before we really get into that, I want to just have a word about words. Incapacitated adult is a horrible word. It is totally inconsistent with the concept of supported decision-making and limited guardianships. But it's in our statute. So I put it in quotes because I don't like it. That's me, and I think most people who have some understanding of this. When you say incapacitated, you're saying they have no capacity to do anything. That's kind of offensive. And the use of the word ward. I mean, words have power. We need to change our language, and that's the language of the law. So the reason that our committee hasn't made recommendation on changes of the language yet is because there's going to be a complete rewrite of the probate code, and that is complicated. And so you don't want to go to the Idaho legislature with sort of piecemeal amendments of statutes when you're really looking at a more comprehensive overview. And I don't know when that, Bob's totally in the know on when that might be another couple of years. Yeah, 2 to 3 years, because overhauling the Uniform Probate Code is a massive project. But one of the things, and I'm actually quite confident that this will be changed, this language will change. It has to change because it affects how people think about it. And we're all about trying to change how people think about this. But this is the law, and the law requires certain things, like helping this person make decisions, like assisting this person in making decisions, not making decisions, helping them manage their funds, not managing their funds. That's really critical language. So I'm not advocating for anything new. I am advocating for the law. You know, this is in conservatorships, same language, maximum self-reliance and independence. These statutes were enacted in 1982 and 1990. What are we doing? So, you know, if this were being followed in all of our guardianships and conservatorship cases, we wouldn't be here. And this is really the mystery to me. Developmental disability, it's the same thing. It's the same kinds of requirements. Self-determination, assisting in meeting health and safety, protecting rights, helping them manage, developing, regaining abilities, liberally construed. That's the intent of the legislature, just expressed in the statute. Why no less restrictive alternatives would be appropriate. Same with conservatorships in DD cases. It's a scaffold of consideration. You really have to dig into it. And if they're able to manage, then you have to dismiss. And while I'm on the subject, I don't want to call anybody out. I'm not here to make anybody feel bad, but I just see this all the time. It's just baked into the practice that when lawyers file a petition for guardianship, they always ask for conservatorship too. Why? If there's no property, and there's no property and there's no income to protect, then you really shouldn't be filing a petition for conservatorship. So I ask lawyers this all the time because I say, no, I'm not going to, you haven't justified it. If you just have Social Security coming in and out with a designated payee, that you can deal that with the guardianship report. You're just complicating their life. Because then it costs $50 to file a conservatorship report. Now, we have fee waivers, and we have to have fee waivers because so many people can't afford it. But still, really important consideration because the court is not supposed to grant a conservatorship unless it's justified and necessary. It's not justified and necessary if there's no money or there's no property. So you know, keep that in mind. That's just a simple thing. But when I ask lawyers, why are you, because I ask a lot of questions from the bench. I just think that's my job. I think that's part of what makes the job so great. Get to have these conversations. You say, well, why are you asking for the conservatorship? oh, well, you know, we can save a filing fee if we file it, and then maybe someday they'll have money. To save the filing fee, it is so simple to just file a motion to add a conservatorship if they win the lottery or they inherit some money, okay? Don't make it more complicated than it needs to be. So, I don't know. That's always been sort of a question that I ask. And at first I felt so silly asking it. I thought, well, of course, people have really good reasons to do this. And I have not yet heard a good one. So, but if anybody, you know, I'm here. I welcome it. If you have ideas about this, I'm happy to consider it. Because really, this really is all about, you know, raising consciousness, learning things from each other, and making a better system for all of us. So, what do all these things sound like? I mean, I know now I'm sounding like Jonathan, but supported decision making, right? Everybody's going to start saying it pretty soon in unison. So the language of the law has been here for a long time. These statutes were passed in 1982. So here's my big question. Why hasn't the practice followed? Why? Why? I'm asking myself this all the time, and so I'm genuinely interested in what people think. I mean, I'll be blunt. I've been guilty myself. Just not thinking about it. Just kind of being rote. And I have changed. I mean, I have changed my practice. I ask a lot more questions. So I think when we do that, though, when we just get into sort of non-thinking mode, we are really not complying with the language of the law or the spirit of the law, and we are doing harm to the people that we're trying to serve. We're violating their rights, I mean, quite directly. And that is something we should all be concerned about. So why do we do this? I mean, help me understand if anybody's willing to say, I mean, we want to fix the problem. And we know there are barriers. I mean, cost is one, more time. Jonathan touched on some of them. I mean, anybody have any notion? I mean, there are lots of reasons. Yeah, what do you?
I was going to share that, and we discussed this before. We know that the school promotes guardianship, and most of the families that I know that I have been working with, they believe what they have been told by the school. That if by age 18 they don't have this guardianship, or a little bit after the 18 age, then they have no rights to help their children, or that's and especially with the Latino community, that is something that it has a great impact because the family has no information about it. And besides that, we have lawyers who are promoting this guardianship.
I think that's a great point, and I think that Jonathan talked about that sort of pipeline from the schools. So people go from the school, they go talk to a lawyer. I'm told I need a guardianship. So who's in a unique position to really deal with that? The lawyers are, because they think they need the guardianship. They were told they need the guardianship. But you, as lawyers, can give them options. You can explain to them what it really means to have your loved one's rights taken away. You can tell them what it really means to have a limited guardianship or set up alternatives to guardianship. You can talk to them about supported decision making. Because I've always believed, not just in this context of the law, area of the law, but in all areas of the law, one of the greatest powers that lawyers have for good is within the privacy of their office, within the attorney-client relationship. You can have conversations with people. You can educate them, give them options. That's one of the great joys, actually, of being a lawyer and helping people through very complex problems, because they're coming to you for your objective, professional judgment. Not necessarily to give them what they want. You know, confusing the client's best interests with what they want is a big mistake for lawyers frequently, and that'll get you in trouble because it raises their expectations unnecessarily, for one thing. And so even if you do a great job, then they're going to think my lawyer is bad if you raise those expectations. But also, they need to understand. And once they understand those options, it's a form of supported decision-making for the proposed guardian. Once they understand those options, they might say, yeah, well, now that I understand that, yeah, let's try these things. I love the question that Jonathan asked. What else have you tried? What else have you tried before you default to something like a total guardianship? That's a really important question. And I ask that question on the bench now. What else have you tried? Why are we going to a total guardianship? Well, because, and I hear this all the time, the school told me I had to. And the lawyers plug into that. See, so lawyers can interrupt that by good explanation to their clients. So I do think part of it is it's kind of baked into the culture of guardianships. That's a really hard thing to overcome, yes.
I think, in my perception, it all comes from a place of protection and fear, you know, like what's going to happen.
And well-meaning.
And well-meaning. I mean, I think I don't think I ever see a guardianship come in where the parents aren't just worried about what might happen, what if.
That's what parents do.
What I often want to show people is, you know, as a crisis team, we do the guardianships, but we also do crisis work with adult development, you know, folks with developmental disabilities. And we see the other side. What happens when you take away their power of choice for 20 years? And what becomes of these people who are incapable of making decisions on their own? They have behaviors because they can't choose, you know, what they're going to make for their own breakfast in the morning. And they, you know, it starts this ugly life cycle. And some people are, you know, at age 25 or 26, able to go to the ERI or somebody and stick up for themselves a little bit, but it doesn't happen very often.
Yep.
And guardian ad litem attorneys aren't doing that advocacy very often. And so, I mean, I just wish that there was a way for us as a whole to show people what happens when you take away a young person's right to make choice at age 18, what the consequence of that is down the line. Because it's ugly.
Yeah, well, and Jonathan's slides show the research. Empowering self-determination, encouraging self-determination creates better lives. And we know that from our own lives. I mean, learned helplessness is a thing, okay? And it's demoralizing. And it saps the life out of you. I mean, the hippiest thing he said was headspace. But it can be soul-crushing, really. You know, and it's terrible, Bob.
One of the problems going away from the school side is that, and there's an answer to it, creating limited guardianships is hard.
Yeah.
It has to be crafted.
Yeah.
We often are working with people, especially in all we're changing constantly. Supported decision-making can be a huge tool in that. Just because you have limited guardianship doesn't mean that goes away. And you can have formalized, if you need it, how you work with those changes as they happen. And even during the day, they're good in the morning, bad in the afternoon, what meds do they have, what stress do they have? So you can draft that, but it takes work. And in terms of what you're saying about GAL, we should be in that case constantly saying, why is this continuing? What is getting changed?
That's right. And we're going to talk a little bit later about the ethical conflict between GAL and being the attorney for the client. Yes?
So one of the issues, big issues regarding to the hospital is, you know, we're the place that people come to when they have dementia. And, you know, as a social worker especially, you know, absolutely support the disability. But the facilities, you know, they can go to, if they need to go to a memory care facility.
Right.
The facilities say, no, not unless they got it right.
Right.
And so
Well, that's a problem, and as Jonathan was saying, I mean, nobody's saying that guardianship isn't appropriate in certain cases as long as it's justified and necessary. But age-related dementias are an issue there. Now, you can still do a limited guardianship, and you can still make it for particular purposes, but they shouldn't be requesting a total guardianship if it isn't necessary. And that's what we're trying to say. Sometimes you know, it's important to have guardianship. I mean, I don't know that we're ready for this. I don't think the hospitals are ready for this. I don't think the healthcare system is ready for this. I don't think the court system is ready for this. They're saying that age-related dementias are going to double by 2020 because we have this big population bubble, and like my father always says, who's going to turn 91 on June 26th, is we're just living too damn long. And he has a point there. We're just so healthy. And he was a physician, and he has dementia now. So, you know, but he's still very conversational, so, and wise. And I think he makes a good point, but there are certain points where, you know, you have to meet people where they are and work with them the way they are. And it is hard, as Bob says, to craft the right document. It's hard to come up with the words. And people like, especially other people who are reading these documents, like real precision. I've had lawyers give me things that were kind of vague but aspirational in some of the language and very specific in other parts of the document. There's nothing wrong with that, because I think it's important for these orders for limited guardianship, if it is justified, to have some language in there that motivates the guardians to do the right thing. I mean, the language that Jonathan illustrated in the durable power of attorney, really helpful to be able to say, look, we're going to give this person some decision-making authority in this particular area, but in order to exercise that authority, they have to go through some kind of particular process of involving the person who's affected by that decision. Let them participate in the decision, contribute to the decision. So, yes, it's hard. It takes a lot of effort, but you know, it's the right thing, and I think that's what the law requires. So it does take more time. I think it takes more effort. I mean, one thing that often comes up is people say, well, it costs more then, and that's definitely an issue in the whole process, is cost. If we could figure out ways to address that, I think that would be great. I think that supported decision-making does address the cost issues, because you're investing that person. You're not, in the decision-making, you're not bringing in all these experts and all these other people. You know, experts can come into it too. Sometimes you have to talk to experts, which kind of maybe brings me to the next point, which I just have a few minutes left here, but I think you need to talk to your client, no matter who you're representing in this various perspectives of representation. What happens in a guardianship? What is a total guardianship? What does it mean? And how can we approach this? And be creative. You're smart people. This is a very individualized process. You know, a word on forms, everybody always wants forms. Forms can be really a death to creative thinking. I mean, it's just kind of check the box, fill in the blanks, and you just conform your thinking to the form. Forms can be a good starting point, maybe. It can generate the juices, but you really need to think about what does this person need? How do we approach this in a way that meets this person's needs? And not just try to fit a round peg into a square hole. So one of the things that you need to understand to get there is this concept of capacity, because we talked about this sort of flipping the switch. Like you either have capacity or you don't. Not so simple, right? I mean, capacity is not fixed. Capacity is not static. It is presumed, first of all, in the law. It has to be presumed. Okay, that's where you always start. It's variable over time, it's task or decision specific, and it can change with circumstances. That's why you need review hearings. Not always, but you can, I said earlier, you can always come back to court. You can always come back to court. Don't resist that. If something needs to be addressed, you can just set it for a status hearing and just get everybody in the same room. Or better yet, get everybody in the same room without going to court and have a conversation. Hey, what can we do? How can we fix this? How can we make this better? It's about conversation. It's just not about getting the order entered and closing the file. Okay? You got to keep up the conversation. There are American Bar Association handbooks for judges and lawyers on capacity that are excellent. They were done in the early 2000s, so they've been around for a long time. I think maybe they've revised them. All this stuff is online. Go to the ABA. All those resources that Jonathan talked about, all the resources are in your materials. Everything's online. There is so much information out there about supported decision making and even forms, but that's my cautionary note about forms. We need more information to make better decisions. And that's partly what the new 5.4 and 54.4, 54.5 rules changed. We didn't really change anything dramatic about what was in the statute. We just changed it from statute to rule with the Supreme Court's support, with the legislature's support, because we wanted to lay it out a little more differently, a little more clearly, and we wanted to be able to address, kind of like a conservatorship or a guardianship, I guess, address potential changes a little more nimbly than having to go through the legislature. Not that we're trying to get around the legislature, it's just a more practical way of approaching something that really is under the oversight of the Supreme Court. So again, we're not saying that guardianships and conservatorships are never necessary or justified. There are some great tools out there. I don't have time to go through all this in detail, but I'm going to hit this slide. Jonathan mentioned it. This is the practical tool. Just read that. It's in your materials. It's kind of a checklist for thinking about it, maybe a flow chart, things you should consider as you work through the considerations of a guardianship or a conservatorship. Then there are explanations of, some ways you could approach this. Think about particular areas of decision making, and a lot of people ask about that. I mean, you think about healthcare, housing, care providers, education, employment, financial, if I didn't say that. Those are areas that you really should consider and think about and try to craft language that is individualized and appropriate for the person that you're talking about. Okay, really quickly, I just want to, this is just some comments about the practical tool, but you can read that. It's so well done, and I've really appreciated what I've learned from that, because that just having a better understanding about capacity and its variability, I think, is essential to try to come at these with some reason and some logic. These cautionary tales I just wanted to mention, because this Rogers case, 150 Idaho 735, 2011 case, Supreme Court. I'm not questioning the decision. I think the decision was correctly decided. The issue with it, however, is that when the Supreme Court made it quite clear that when the court imposes a total guardianship, it is equal to a finding that this person has no capacity. No capacity. And the language in it is, says a finding that one is incapacitated in a grant of unrestricted guardianship powers represents a finding that the ward lacks all capacity to make decisions and take actions that protect his or her well-being. Do you really want to do that? Because in that case, this gentleman who was under total guardianship arguably had some capacity. The son got a life insurance policy, and the insurance company challenged that on voidness, that it was void because he did not have capacity. And they didn't have to pay a $200,000 life insurance payout. Now, what's really significant to me about that decision, though, is that the Supreme Court went through an analysis of the statutes I showed you about how guardianship should be limited, how they should recognize self-determination. And Justice Horton wrote, well, if a magistrate approved a total guardianship, therefore the magistrate must have gone through these statutes, and therefore this person has no capacity. That's a legal finding, a binding legal finding. And that is the cautionary tale. Like you enter an order like that as a judge, or you ask for an order like that as a lawyer, there may be unintended consequences, unintended legal consequences down the line that you may regret. And that is a significant decision. Everybody should read it because it's really important to understand what happens, what the Idaho law says about that when you enter a total guardianship. The other one I added, just because it's just a heartbreaking article that was in the New Yorker by Rachel Aviv about just a system of exploitation in Las Vegas about guardianships, where there was a system set up, and judges were complicit in this. I don't know if they were knowingly, complicit, but they were complicit because they were just signing off with having professional guardians come in. These people never even went to court. There was no justification. They got guardianship. They were taken out of their homes. They lost their property, lost total control over their lives. It's a great expose, and it's incredibly well written. I will tell you, now I've seen some cases of exploitation, but nothing at a systemic level like this. So the good news is I think we're really doing pretty well in Idaho. We can do a lot better, okay? We will do a lot better. So I guess I'll close just by saying that we need all of you in a collaborative process, okay, to really make this work, to change the practice, to help us comply with the law. And if we do that, we'll all be making better decisions as judges, as lawyers, as social workers, as guardian ad litems, as guardians. But most importantly, the people who we serve, the people who are supposed to be protected under this system, will be making better decisions too. So I'm happy to answer any questions, criticisms, whatever you want to say, comments. Yes?
So, obviously the agreement is one thing, the language there may or may not be enforceable, but if we're talking about including some sort of language in an order, do you have any suggestions or best practices for including that kind of language that might help with enforceability, or that might be?
I think if the language is fairly clear, I mean, I'm talking about the aspirational language, that's difficult to maybe enforce. But if there are specific areas, let's say Johnny has discretion over $200 a month in spending, however, we'll need to elicit some support from this person, and this person if he wants to buy something over that amount or wants to spend more than that much money in a month, without taking that away, but just, I call it, I don't know if this is the right way to think about it, but kind of curbing. So this is being a limited guardianship, so you sort of curb certain areas and put some speed bumps in maybe, so that you can protect somebody from like some kind of disastrous decision while still letting them make some bad decisions, like buying something they probably shouldn't be buying, like we all have. I mean, so it's not, you know, that really kind of opened my eyes the first time I heard Jonathan talk about, you know, the bad decisions we all make in life, and just think, why just because somebody makes a bad decision do we think that they have no capacity? That's an unfair, that's an illogical conclusion to draw from that. Yes?
I would like to suggest if we can work together, like creating a committee where maybe working with the DD Council in establishing a collaboration with the schools, because what is sad for me is that I have been in many IEP meetings, especially with high school students, and the teachers don't even look at the students when they are discussing the goals and the IEP. So, and if we're promoting, supporting decision making, we have to start changing the culture and how those type of meetings are, you know, happen.
Like Jonathan said, stop the siloing.
So
Stopping the siloing means you have to come together. This is a start. I mean, people can come together. You can set up meetings. And by the way, I mean, the Guardianship Conservatorship Committee, Supreme Court Committee, is very open, okay, to input. You know, send us your concerns, send us your questions, send us your ideas. It's a great committee. I mean, we really talk quite openly about all kinds of ways to make things better.
Then my other commitment is that I have been working with Latino families, providing them information. This is going to be a good topic, and I will talk to Lupe about bringing this information for them so they know that they will be aware of there are other choices for them, not to look into
Right.
the guardianship process.
Well, I think what I hope is ultimately, as the culture shifts, that people are educated, okay, in the schools, that there are options, that lawyers educate them, that the guardian ad litems educate them, that the courts educate them, that everybody says, look, yeah, we've done this, but we're going to do better. There's a whole range of options available here. You don't have to do this one thing just because that's what we've done.
And then my last thing is, why if we are trying not to promote the guardianship, why is it so hard for people to get up from it, to terminate it legally? I have known two families who wants to terminate guardianship, and according to what they said, it's horrible, the process, and they prefer to stay like that because they have no choice.
Well, I don't quite know how to address that. Yeah. Terminating, and I haven't talked about minor guardianships. That's sort of a different thing, a little bit. Yeah. Well, I would say if they're having trouble with that, they should talk to a lawyer. Yeah. Oh, yeah. Oh, the monitoring coordinators. And that's great because I'm fortunate enough to have Kristen Finley in the 2nd District. She's doing a great job. And so people will just contact her. This is a great part about relaxing the ex parte rules with regard to conservatorships and guardianships. So I'll get a report, and then I'll send it out. I give everybody notice and set it for a status hearing, and she'll make a recommendation. Let's say that, you know, that doesn't seem like there's any continued reason to keep the guardianship. And we'll have a hearing, and a lot of times everybody's self-represented. I deal probably half the stuff I see these days, I'm dealing with self-represented litigants. You can also go through the court assistance office to file a motion. You can tell them to go to the court assistance office, talk to the monitoring coordinator, and get it in front of a judge. And involve the guardian ad litem, because guardian ad litems are supposed to be responsive to that. And again, we're going to talk later about this potential conflict between between being the lawyer for the person and being a guardian ad litem for the person.
Judge is going to be around for questions.
Yeah, I'm happy. I'm very accessible. Thank you.